Ever since Rachael Rollins was elected Suffolk County DA last fall, there's been intense scrutiny of the policies she's implementing as DA, including the list of 15 lower-level, nonviolent charges she said she would not prosecute, including trespassing, shoplifting, drug possession, and drug possession with intent to distribute. Charges Rollins says are closely linked to problems like poverty and mental health issues and are driving the mass incarceration of African Americans and Latinos. A few months ago, there was a sharp and very public back and forth between Rollins and the Baker administration, which eventually simmered down. Now the Boston Globe is taking heat for a story it published earlier this month titled "Stopping Injustice or Putting the Public at Risk, Suffolk DA Rachael Rollins' Tactics Spur Pushback." That piece prompted a letter of protest from 19 Boston area academics who said the Globe's write-up lacked key factual context and created an erroneous impression that Rollins' policies are making the Boston area less safe. Now more than ever, the letter said we need journalism that exposes rather than stokes baseless fear and irrationality. So did the Globe get it wrong, or just subject Rollins' new approach as DA to a reasonable degree of critical scrutiny? Two of those 19 academics join me now. Margo Lindauer is the director of the Domestic Violence Clinic at Northeastern University, and Leo Beletsky, a professor of law and health sciences at Northeastern. Thank you both for being here.
Thanks for having us.
Thank you for having us.
Journalists, as you've probably experienced, love to criticize the work that other people do, but we tend to get prickly when people criticize the work that we do. What was the biggest problem with the Globe piece as you two saw it? Or were there problems throughout, or were there one or two things that really stood out as egregious?
So I don't have one specific problem with the Globe piece. I think one of the issues is that it has only been 6 months since DA Rollins took office, and many of the policies that she has implemented and many of the decisions that her aligned prosecutors are making are similar to decisions that have been made in previous eras. They're now codified in the 15 no prosecute list that was part of the memorandum that DA Rollins put out. However, many of the practices are not unlike what has been happening previously.
You're talking about here in Boston?
Here in Boston.
Dan Conley, for example, did some similar stuff.
Exactly,
yeah.
In Suffolk County here in Boston under DA Conley's reign. And the other part that I think there was some subtlety that was missed in the Globe article is that DA Rollins is really trying to work on rehabilitation. And Professor Beletsky can talk about the substance.
You can use first names.
Okay. Professor Beletsky can talk about individuals who are struggling with substance abuse and poverty and other issues. And so I don't think there was one problem in particular, but there was some subtlety that was missed.
Now I don't know. I was going to call you Leo. Now I don't know if I should call you Leo or Professor Beletsky. All right, Leo, can you just briefly talk about some of DA Rollins' thinking when it comes to people who are dealing with substance abuse and how that has, I guess, helped drive some of the changes she's making?
Yeah, sure, absolutely. So first of all, just a very short note about language, and this is totally mainstream to call it substance abuse, but there's actually a movement to using substance use more, because abuse in and of itself is a criminalizing term. Mm-hmm. Sorry to be pedantic.
No, that's totally fine. You get aware in the media. I was aware, for example, don't call people addicts, say they're people struggling with, but I hadn't heard about that one.
Yeah, so abuse, we talk about child abuse, domestic abuse, and that automatically...
The verdict is in.
The verdict is in. And in many ways, we are trying to, as DA Rollins is trying to do, we're trying to move away from criminalization and towards a more humanistic and health-based approach to substance use. So that should be reflected in the language that we use. And there are some resources online also to check out to kind of educate yourself about the various language shifts that are happening. But having said that, I think that one of the key elements of DA Rollins' approach is to really highlight the role of prosecutors in affecting kind of the war on drugs that we've been experiencing for several decades. And there's a lot of recognition now, both on the right and the left, that those approaches have failed. We are in the midst of probably one of the most serious drug-related crises in our history, and that comes at a tail end of basically huge push towards criminalization. So clearly, those approaches, mass incarceration and arrests, and making sure that people are experiencing the harshest possible penalties for drug-related crimes, all of that has not borne the results that those laws were touted.
And my understanding is that, for example, if someone has been incarcerated with an addiction, treading carefully here, if someone comes out, they're more likely to overdose, for example. Right?
Yeah, so a period of incarceration yields about 120 times the risk of overdose after reentry. So there's a problem with fatal reentry. Yeah. And that's something that we're really trying to avoid, minimize the contact of people with substance use disorder with the criminal justice system, because that is something that perpetuates and aggravates overdose risk.
So this context is really good because we have, unfortunately, less time than I'd like. I want to ask you about a couple specific pieces of the Globe piece. There was a lot of discussion of a story involving a woman who was attacked in Charlestown. I guess she was just snapping pictures. A guy thought that she was taking pictures of him smoking marijuana and beat her pretty severely to a point where she still has lasting, I think, neurological damage from that. And the Globe highlighted this because there was an agreement reached under D.A. Rollins' leadership, under which, among other things, this was pled down to a misdemeanor. It was a misdemeanor assault rather than a felony. As a matter of journalistic principle, taking into account everything you've said about the wisdom of D.A. Rollins' approach, is there anything wrong with a media outlet highlighting, okay, here's an example of a use of prosecutorial discretion that some people might find troubling? Is that bad, or is that okay, do you think?
So my personal opinion is that is okay. And there are always going to be outlier specific cases. And I think that we can learn from specific cases. In my mind, as someone who represents survivors of violence in court, in the Boston Municipal Court system, being a victim advocate and being for criminal justice reform are not mutually exclusive. I think one of the things that story highlighted in particular is some of the issues with how to represent victims in the criminal justice system. That is not unique to D.A. Rollins. That is something that has been an issue for forever, under other DAs as well. And so that specific case is not an anomaly.
I want to roll, and then we'll go to you. I think you may get the last word here. One other piece of material that the Globe put in its coverage, it was a judge questioning the wisdom of the procedure that the DA's office was using in a particular case where a guy had broken and entered and stolen a large amount of material. Let's take a quick listen to what the judge had to say.
Commonwealth's new policy, the Commonwealth is asking for the court to further this arraignment so that the parties can work out a restitution order that may resolve this matter.
I can't believe that your policy suggests that in this case, Commonwealth. $6,200 is the alleged value. This gentleman's Board of Probation record, and the Commonwealth's position is that you're seeking a further arraignment date?
That is my understanding.
So obviously that particular judge was skeptical. I'm wondering if in the judiciary there is skepticism of the sort of approach that D.A. Rollins and others are using. It sounds to me, talking to the two of you, like in academia, legal academia, a lot of people endorse it. Are judges slow to approve of it the way that you two might?
Well, absolutely. I'm not sure that there's a kind of a consensus within academia either. I think it is a little bit more diverse. We come from, I think, a more reform-minded camp. But I think it's worth saying that, the baseline from which we're seeing all these reforms is a baseline of extreme over-criminalization as far as substance use, as far as other kinds of crimes. U.S. is a total outlier when it comes to our criminal justice policies, the population rates of incarceration, and really pretty much all metrics when it comes to criminal justice. So when you're talking about changing the system, there are a lot of people in that system who make their living being part of that machine. And there certainly is a number of kind of vested interest and conflicts of interest to be perfectly frank, that are at play, and also just the way of doing business and the status quo is changing, and that always ruffles feathers.
Unfortunately, I got to cut you off there. I wish I had more time with both of you. Margo Lindauer, Leo Beletsky, thank you both.